We may be back at the United States Supreme Court within the week because a Ninth Circuit Court of Appeals dominated by Trump appointees just late last night put a pin in the temporary restraining order that was granted by Judge Breyer in California in favor of Governor Newsom to take Trump and his boot off the throat of California and return the National Guard to the control of the California governor. But built into that particular order, which I'm going to report on, in which the Judge Breyer, a trial court judge, found that Donald Trump had acted illegally, had acted unconstitutionally, had violated the 10th Amendment of the Constitution, all in taking over the California Guard because there was no real rebellion. There was no evidence that Donald Trump could not faithfully execute his laws, and therefore he was not empowered to do what he did. The judge also found that it was chilling for Donald Trump to try to convert what was effectively a peaceful protest against his policies, which is protected by the First Amendment of the Constitution, try to convert it by feat of alchemy and declaration into a rebellion, because that's the term that's used in the 1903 statute, in order to try to suppress and crush First Amendment expression. And that gave the judge a lot of pause. Me too. Now, speaking of pause, we've got the Ninth Circuit Court of Appeals with a randomly selected panel, but one that favored Trump once again. It's the second randomly selected panel of appellate courts in two different locations in the last week that have been dominated by Trump appointees. It shows you that voting matters, that elections matter, because that determines at the president level who's going to be your judges. We're going to be a judge together right now on Legal AF as I cover this fast-breaking story. And I tell you what is going to happen between now and Tuesday. Circle Tuesday on your calendar. It's a red letter day in this particular case. I'm Michael Popok. You're on Legal AF. Speaking of red letters, thumbs up. Hit the subscribe button. Let's get into it. Yesterday, late afternoon, after 6, 7 o'clock at night, we got the order. We got the order from Judge Breyer. Judge Breyer, the brother of retired Supreme Court Justice Stephen Breyer, Judge Charles Breyer up in San Francisco, went through and granted the order. Let me read to you from the order, then I'll tell you, of course, that the Ninth Circuit has stayed this order for at least 3 or 4 more days. But let me read to you. Let's start with the order. The order says that this is the first page of the order. On June 6, 2025, the federal government initiated immigration raids across the city of Los Angeles. The vocabulary that the judge uses is important. Protests swiftly followed. Some individuals involved in those protests were unruly, even violent. The following day, President Trump ordered that members of the California National Guard be federalized and thereupon assume control of these forces. Now, the Trump administration wants you to believe that he's the commander-in-chief. He can do anything. But he cannot, because the 10th Amendment says he cannot. The 10th Amendment reserves in the states and in the people all power that's not given expressly by Constitution or act or statute by Congress to the federal side, to the Trump side. Yeah, that's the very foundation of our system of federalism. And this is how we got the union together with that agreement. Donald Trump is attacking and trying to rip asunder the union of the United States of America. The judge continues on page 1. At this early stage of the proceedings, the court must determine whether the president followed the congressionally mandated procedure for his actions, a 1903 statute. He did not, Judge Breyer ruled. His actions were illegal, both exceeding the scope of his statutory authority and violating the 10th Amendment of the United States Constitution. Therefore, he shall therefore return control of the California National Guard to the governor of the state of California. The judge then goes through everything that's happened. One of my favorite lines is when he's analyzing the word rebellion, which Donald Trump claims in one of his statements that a rebellion is happening, giving him the right, because that phrase is used in the statute. The judge took a look at the reporting and he said, yeah, I get there were some bad actors out there. And they were even throwing, get this, mangoes and water bottles, maybe parts of concrete. I get it, chairs, but that's not an armed rebellion or insurrection as that term has ever been used since 1903. And he looked at all the dictionaries, all the dictionary definitions, and the judge is like, yeah, this was a peaceful protest that had elements of unruliness and some violence. It's being handled by law enforcement, does not give you the right to invoke that particular clause under which we call the 12406 statute, 10 U.S.C. 12406, also known as the Militia Act of 1903. He also takes on this argument that we see over and over and over again in court filings by Donald Trump and arguments made that the judiciary cannot provide any oversight over Donald Trump. He can just be rogue without any evidence, without any congressional power, just cite to his big war dance, his big war powers, and that's enough. That courts don't have the power to provide oversight over the president, that it's not justiciable. That's a fancy, highfalutin way of saying courts have no role to provide oversight. And this judge and every other judge has said, including up to the Supreme Court, that's ridiculous. You make a call, you determine what statute you're going to use and what powers you have, but we'll tell you whether you did it right or wrong. Donald Trump's argument is, I called it a rebellion. That can't be challenged. Judge is like, what are you talking about? Of course it can be challenged, just like it can be challenged about whether there's a war or predatory incursion under the Alien Enemies Act or anything else that you're doing under phony emergency war powers. So he takes down justiciability. He also cites, and I love this part, he takes a framework developed by Judge Rodriguez in Texas back in May involving the Alien Enemies Act. Judge Rodriguez, a Trump appointee. So Breyer grabs that framework and says, I think it's a very, very good framework to use about whether something is justiciable or not. Donald Trump wants to argue and jump up and down that everything's a political question. That's a term of art from the Supreme Court that says if it's a political question, you got to let politics play out. You don't like what's going on, you vote them out. You have to do it at the voting booth, not in the courthouse. But that's only under very unique issues, not statutory declarations of definitions. That doesn't count. And then finally, the judge, after going through the definitions of rebellion, which he defined as an open, organized, and armed resistance to an established government or ruler, always organized, the common themes of the definitions from that era, including back in 1891, is an open and avowed renunciation of the authority of the government or the taking of arms traitorously to resist the authority of the government. And he's like, well, mangoes aren't going to do it. Mangoes are not going to cut it. I just love that particular comment on page 19. Even accepting the questionable premise that people armed with fireworks, rocks, mangoes, concrete, chairs, or bottles of liquid are armed in a 1903 sense, and there's no evidence that anybody actually had firearms. There's little evidence of whether the violent protesters' actions were open or avowed or coordinated. Moreover, he also finds chilling the attempt to convert First Amendment protest into a rebellion. He says on page 20, moreover, the court is troubled by the implication inherent in Trump's argument that protest against the federal government, a core civil liberty protected by the First Amendment, can justify a finding of rebellion. The U.S. reports are chock full of language explaining the importance of individuals' right to speak out against the government, even when doing so is uncomfortable, even when doing so is provocative, even when doing so causes inconvenience. But that doesn't mean you can then convert it. A peaceful protest does not lose its protection merely because of some isolated individuals acted violently outside the protection of the First Amendment. That on page 21. Now that comes up with a notice of appeal, a motion, emergency motion for stay to the Ninth Circuit Court of Appeals. The judge anticipated, basically invited the appeal on this core, very complicated issue because he stayed his order, making it not effective until noon Pacific time today. Well, Donald Trump didn't wait that long. He filed his notice of appeal in San Francisco at the Ninth Circuit. It's a one-page document. He filed another document, which was a motion for emergency stay, asking the court to stay the order. Don't force Donald Trump to turn back the troops to Governor Newsom, at least until the appeal is over, which could be months. Even if they do emergency application, it's going to be at least a month or two. You know, I would think most of those things are over by then that are going on in LA, although who knows? The 3-judge panel gets picked. It is Bennett, Miller, and Sung, and we slap our foreheads over on Midas Touch and Legal AF. Bennett, Trumper. Miller, pragmatic, moderate Republican, appointed by Trump. Sung, Biden. But they issued a 3-0 decision, at least for now, that they are going to grant an administrative stay, which I'm going to explain, which I have here in my hot hands and will put up on Legal AF Substack. It says the court has received the emergency motion for stay pending appeal. The request for administrative stay is granted. And then they set up a briefing schedule starting Sunday night, timing out with a hearing on June 17th. So we got a hearing on a Tuesday at 12 p.m. Pacific time in front of this 3-judge panel. The sole issue is whether a stay should stay in place for the duration of the appeal, no matter how long that lasts. This is not a briefing schedule for the underlying substantive issues on the appeal. The appeal being, did Donald Trump violate the 10th Amendment? Did Donald Trump have the power under the 1903 Militia Act to invoke the rebellion standard or trigger it to take over the National Guard in California and divert its resources away from what it's supposed to be doing: drug interdiction, border security, natural disasters, protect the state. That's the underlying appeal. But I want to make it clear, what's not at stake even in the underlying appeal is whether Donald Trump's use of the Marines and regular force military violates the law, the Constitution, the Posse Comitatus Act, because the judge in the temporary restraining order said, I don't need to reach that issue because I'm going to grant the temporary restraining order in favor of California on the 10th Amendment and on the violation of the Militia Act from 1903. So that issue is not properly before the court. So I want to make sure people are clear on this. It's only going to be about the 1903 Militia Act and the 10th Amendment. It's not going to involve whether the Marines were properly sent in or not, or if that violated the Constitution. But the issue only for the appeal this week is only on the stay. Is there going to be a block of that order for the duration? Then they'll say, let's say they say, yes, we're going to block it for the duration because we want more time. That's a win for Trump for now. Then we'll have to see who takes it up to the United States Supreme Court on an emergency application based on that, based on the stay. Having granted the stay, generally Supreme Courts will keep a stay in place, but they can do their own independent analysis and determine whether Donald Trump abused his power or not. Another example of abuse of power. So I think we're well on our way to our 20th or so emergency application to the United States Supreme Court. That could be as early as later next week. We got briefing over the weekend that's been ordered by Trump administration side and by the California side, with a hearing on Tuesday. I'll follow right here on Legal AF. Take a moment, hit the free subscribe button on Legal AF. Come over to Legal AF, the Substack, where I'm posting all of these orders and motions and things under Filings AF. And then also, we've got Legal AF, the YouTube, the podcast on Wednesdays and Saturdays at 8 p.m. Eastern Time. We're the number one law and politics YouTube podcast out there based on the rankings. So that's all because of you. We appreciate it. Let's pump up our audio downloads on our audio podcast platform for Legal AF as well. Till my next report, I'm Michael Popok. Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.